SJC-11801, Walter E. Fernald Corporation v. Governor of the Commonwealth and others.
Good morning, Mr. Donnelly.
Good morning, Chief Justice Gantz, Associate Justices. May it please the Court. My name is Joseph Callanan. I'm a Supervising Assistant Attorney General, and I appear on behalf of the Commonwealth Defendants. We ask that you affirm a decision of this Court, Executive Heir, from nearly 50 years ago that held the Commonwealth had retained its sovereign immunity regarding declaratory judgment actions over disputes about whether land is public. Now, that case is one portion of the widespread protections public land has to a much higher degree than private land.
Only if it's determined to be public land in the first place.
Well, the idea of sovereign immunity is, can a private entity drag the sovereign into court over a dispute the private entity has with the public?
Well, wait a minute. This is just, it seems to me in a certain way you're just putting the cart before the horse here. I mean, doesn't it have to be determined whether or not it is or is not public land? I mean, if somebody decides that a portion of a land that I own is public land and does that by way of a statute that just dedicates it to public use as wilderness, it seems to me that it is the government that has the burden of showing that it is public land.
And you would say that she would have to now then register her land and go to land court and go through a whole registration process to challenge that?
That is counterintuitive.
Let me explain.
Best.
Okay, let me explain, Your Honor. But yes, if in that circumstance you as a landowner has a dispute with the Commonwealth, that resolution, the legislature has determined the exclusive remedy is to go to land court and seek registration. Now,
I think that's an astonishing proposition.
But it's the same principle the United States Supreme Court has decided as to federal land. Because
I mean, Justice Link, the premise of your statement is that it is Commonwealth land. That's the dispute.
But Your Honor, that's a fallacy.
And that's the difference of executive heir. That was registered to the Commonwealth, that land.
And that's the second point I'd like to get to. But that's a fallacy to just deny the antecedent. What we're talking about is a private entity has dragged the sovereign, in this case, the governor, into court.
The governor's out of this case, so let's just talk about the agencies.
And two state agencies to resolve a dispute over Title II land.
Don't you think they could say they got sort of dragged into this by virtue of a statutory enactment that the governor that allowed the Commonwealth to claim that this was public land, and that when they went thinking it was private land, as it had been for, in their view, with some reason, private land for many years, that it was they who could not sell that land, who had been dragged into a controversy by the government?
Your Honor, it's our position that the public and the executive agencies have thought this has been public land since the 1920s. So we have been dragged into court to resolve that dispute. Now, the United States Supreme Court has said in Block v. North Dakota and the Potawatomi Indian case in 2012 that the federal government has waived sovereign immunity for a quiet title action under federal law, much like this state has waived sovereign immunity for a registration case. And the United States Supreme Court has said not once but twice, you can't do an end run around the exclusive waiver of sovereign immunity.
Are we bound by what the United States Supreme Court has done?
No, Your Honor, but the plaintiffs would ask you to follow the main Supreme Judicial Court on a case that's much different. I am suggesting if you're going to go outside this jurisdiction, first of all, you don't have to, because you have executive heir, which has never been called into question. Its rationale never been overturned by any enactment of the legislature or this court. But if you were to go outside the jurisdiction for guidance, it's the United States Supreme Court that's addressed this same issue. A waiver in one statute does not allow someone to end run through another statute to drag the sovereign into court over a dispute over land. As a private entity say, private land. As a state agency say, public land.
But that means, pragmatically, any time the Commonwealth, however irresponsibly, I'm not saying this is irresponsible here, but you basically declare you now own my land. You have no right to do so. And now I can't sell my property. You were essentially saying I have no choice but to seek registration of my land, simply because the Commonwealth has made that allegation.
It's not an allegation that we made, Your Honor, okay? It's based on the law.
I understand, but that's what's being decided here. But you're saying that whenever the Commonwealth says we own that land, the landowner can't go to court to resolve that dispute.
They can go to court, Your Honor. They can go to land court. They have a remedy. This is not like Maine where there was no other remedy. In Welsh v. Maine...
The remedy would require me first to seek the registration, correct?
Correct. But imagine in the 1960s, you were injured by a state employee in a car. At that point, you had no remedy. We had not enacted the Massachusetts Tort Claims Act. So if you were injured grievously, you had no remedy.
Yeah, but the Fifth Amendment has always said that if the government takes property, it has to pay just compensation for it. And one of the claims in this case, although it was dismissed out because the land court didn't have jurisdiction, is the takings. And the government certainly hasn't invoked sovereign immunity for purposes of taking. Had they filed this in Superior Court and sought damages, you would be trying to explain the value of the land that you took.
No, I wouldn't, Your Honor, because we did not take it.
Then you would be explaining that you always own the land.
That's right.
Correct, Your Honor. And I'm prepared to address that issue if you are uncomfortable with that part of it. But the issue here is a private entity has dragged the sovereign in to court to determine title, whether it be a private entity or a public entity. And that's executive error. And this court in 1961 said private entities can't do that.
Executive error, could I just ask you this, though? Executive error, case was brought, number one, land was registered to the Commonwealth. Number two, case was brought in, so it dealt with registered land. Case was brought in the Superior Court, which doesn't have jurisdiction over questions about registered land. The fairly brief discussion of the issue in the opinion by Chief Justice Wilkins is it doesn't, the sovereign hasn't waived immunity for this type of suit. I mean, the meaning of that is not crystal clear. And it could mean simply that sovereign immunity isn't waived to be in the Superior Court to under declaratory judgment, to dispute title to registered land.
Your Honor, I would agree executive error isn't clear, but this court has been clear in subsequent cases that executive error was about sovereign immunity, specifically Revere Housing and Franklin Foundation. I'm sorry, Franklin Foundation was before. Revere Housing is the case that talks about executive error. The issue was sovereign immunity. And what you just suggested is what the land court did, and it's anachronistic. What the land court said that the land court has exclusive jurisdiction to determine disputes over registered land is true today, but it was not true in 1961. And I cite the case of Cesaroni versus Firmino. The case is 340 Mass 638 from 1960. And there this court said, the only issue to be decided is whether the Superior Court sitting in equity has jurisdiction over the parties and the property because it's involved a parcel of registered land. This court said in 1960, before executive error, it appears that either the land court or the Superior Court could take jurisdiction. So the land court was anachronistic in thinking in the 21st century, executive error couldn't have done this. But it failed to understand that in 1960, the case could be heard in Superior Court and in land court because the rationale the court is relying on is an amendment to the land court's jurisdiction in 1984. So taking ideas from today and facts that are true today and assuming those facts are true in the middle of the 20th century, the early part of the 20th century, and the 19th century is anachronistic.
Is this a case that?
It was not cited in my brief, but I'm sorry, it's
The site again?
340 Mass 638. Cesarone, C-E-S-A-R-O-N-E versus Firmino, F-E-M-I-N-O.
If I can turn, let's put aside this issue for now, because you have, let's focus on the merits, assuming we get to it. Do you agree that at some point in time, the Fernald Corporation owned this land?
No, Your Honor.
It never owned the land?
Correct.
Even back when in 1923?
Correct. And let me explain why.
I mean, it was private money, wasn't it?
Yes, Your Honor, but the source of funds is not dispositive. The entity's authority is the most important issue here. So, again, it's anachronistic to think, although it's a private corporation today and there's a separate state agency today, that existence has not been the case for the 170 years of this relationship. During the critical time when the land was purchased between 1923 and 1969, there was only one entity. It was a public instrumentality founded in statute, funded by the legislature, and its authority was in the general laws.
The fact that it was created by statute is not dispositive either.
It's important, Your Honor.
Why? Because they were all created that way.
All corporations were in the 19th century, but just because a railroad company was created by a statute, that doesn't mean that railroad company is then incorporated in the general laws like this corporation was. If you look in Chapter 123, Chapter 25 of the general laws in 1921, the version of the general laws when this land was acquired, this corporation is codified in statute. So it's not just a special act that created the corporation. It was a special act that amended the general laws.
But the special act said that the corporation had the power to handle its private funds exclusive of public oversight.
That's true before the Anti-Aid Amendment. Because in 1918, the Anti-Aid Amendment said any public appropriation cannot benefit a private party. It had to be under the exclusive control of public officials and public agents.
School was.
Only at that time, but not beforehand. In 1918,
The school, not the corporation, the school.
the school and the corporation,
Right,
after
but after 1918, the school was in public.
and so was the corporation. They were one public instrumentality. The corporation.
Why did they have separate books, separate treasurers, separate everything else?
Sure, but they were one public instrumentality. Think of a town. The town administrator keeps its records. The Board of Selectmen keeps its records. The Department of Public Works would keep its minutes. But here, there's only one set of minutes.
But the act of the legislature also referred to them sort of schizophrenically. It referred to the corporation, and then it referred to the school department. The legislation, in effect, recognized that this board of trustees were wearing two sets of hats, one for the public set of its books and one for the private set of its books.
I would disagree, Your Honor. It's not schizophrenic. It's ambiguous because the corporation and the school had the same name. But how do you resolve that ambiguity? They say because they're separate entities. If you look at the law, and again, not be anachronistic, but remember the times that we're in. This was a common occurrence. Today we may have a highway administrator. Back then we had a board of public works. Today we may have a commissioner of the Department of Conservation and Recreation. Back then we had two boards of state parks. The Metropolitan District Commission with commissioners, but also the Department of Environmental Management with the Board of Environmental Management. This was a common setup for government at this time, that you had boards overseeing agencies.
Then why did the legislature make this particular corporation, unlike the other charities that were set up by the legislature, subject to both Chapters 38 and Chapters 44 of the revised statutes? Chapters 38 being the manufacturing corporation board of structure, or structure of governance.
And I'm not sure, but my best guess to answer your question is that the setup of this board was different because the trustees came to the legislature and asked to be incorporated into state government. So after 1918, and again, trying not to be anachronistic, Before 1918, there were two separate entities, yes. But after 1918, there's only one public instrumentality.
Did the corporation or did the trustees ever acquire land with public funds and put those funds in the name of the Commonwealth?
Yes.
Not these disputed parcels, but I believe they did in other circumstances.
Okay.
But
And they don't ever say that those are their parcels. Those are the Commonwealth's.
I understand that, Justice Bossford. But I want to point out one thing with my last minute. To understand that they're one public instrumentality, check their minutes. If they were truly separate, why are there only one set of minutes? And that one set of minutes is on state stationery. And why is state stationery important? Because the first line of that minute, that document that has the minute, says Commonwealth of Massachusetts. The second line says a name of a state agency. And the third thing on those minutes, if you look, is the seal of the Commonwealth. If they were truly a private entity at that time, it would be illegal for a private entity to use the Great Seal of the Commonwealth for its own purposes. So they ask you to understand an ambiguous term, the name of the school, which at the same time was the name of the corporation. And how do you resolve that ambiguity? They suggest by saying they're separate entities. We suggest that would be illegal, and the more reasonable understanding of that ambiguity is they were one public instrumentality, which was common at that point. I see that my time is up, and unless you have any other questions.
Great, thank you.
Thank you, Your Honor.
Good morning. Thomas J. Frayne and Charles Alex Hahn with me for the corporation. I did want to take
Could you address the minutes issue?
yes, and I do not believe that every set of minutes are on state agencies stationery.
Is it correct that post-1918 there was a single set of minutes for both the school and the corporation?
No, there isn't. The corporation had a requirement in their bylaws that they meet at least annually separately, which I assume they do, but that's not part of this case. The boards, my understanding is that the minutes, from my observation, they're not always on state stationery, but that the person taking the minutes, the superintendent of the Fernald School, was the one handling the administration of the memorialization of those minutes. That's my understanding of that.
So your understanding is that they really were school minutes as opposed to corporation minutes? Or were they meant to be both?
The school, according to the bylaws, the school had to meet quarterly, which they did meet quarterly. They met, my understanding is, at the what's until recently known the Fernald Developmental Center. That is where they met. The corporation's bylaws controlled those meetings. They controlled the operation of the school right through till 1986. And so they empowered the governor's appointees to the school to act on behalf of the corporation so long that the requisite number of corporate trustees was present at that meeting. So that's what you see in those minutes. And every single time, for every single deed in question here, the minutes are expressed that it is the corporation that is acquiring these parcels with corporation's funds.
Now, when the school acquired or used public funds to acquire real estate, how was that reflected in what sets of minutes?
To the extent that issue, and it would be the acquisition of land in Waltham, when the school was moved from South Boston to Waltham, those funds were appropriated by the legislature, and those discussions are in the minutes. The deeds are in the name of, the grantee names are in the name of the Commonwealth of Massachusetts, not the school, not the corporation.
Wasn't I thought some of those parcels were also, maybe that's the deed, but because the legislation said to hold in trust for the Commonwealth, right?
And that is incorrect, and that is cited in their brief.
No, the legislation. I understand the brief says the deeds say that, but I'm saying the legislation, didn't sometimes the legislation in giving money to purchase property would say this is to buy. These are not issues, these are not parcels in dispute in this case, but that's what I understood from Judge Long's decision.
I believe that at the time, the disparate nature of the Commonwealth's governance, that they would assign downstream bodies to acquire property. And in that type of entity, like the Rentham Developmental Center, which is formed by statute in, I think, 1906, 1907, that language is in there. For the Fernald Corporation, there is no language in the deeds, there's no language in the minutes anywhere that says the corporation has to hold the land in trust for the Commonwealth. That is mentioned in the Commonwealth's brief, but that is inaccurate.
Mr. Frayne, is this sui generis? Was there any other arrangement like this that you're aware of that we could look at to see how it operated?
I believe this is a very unique situation, and trial counsel John Donnelly said it's a case of first impression, and I would agree with that. But what is clear is that this is a private entity. It was formed by the legislature for retarded people, forgive me for using that name, and the words they used back then are far worse. But there was no services for retarded people. The cities and towns and the families were handling it by themselves. So Howe and the other people who formed this entity did that to lift these people up and protect them. And right through till 1987, when they created the Department of Mental Retardation, the formation statute, enabling statute for DMRs, expressly took the right of the corporation to name Fernald trustees. It took it away from them. But until that time, right through
School trustees.
the school trustees, it took...
So the government wasn't doing anything back when this all began. This began as a private effort, society concerned for its own members, and it only later on became a government function. Is that how you understand how this relationship developed?
Absolutely. Those citizens and all the members of the board, they were never paid at the beginning until, I think, 1909. Even the doctors were volunteering their time. That's all part of the record. The corporation never becomes a state agency. There's not one shred of evidence in the record that the corporation ever becomes a state entity.
Let me just pause for a second to clarify as to the record. When Judge Long made his findings, did he do it solely on the basis of documentary evidence, or did he take any testimony?
It's a cold record.
Okay.
There was no.
So we're in the same position that he was in.
Exactly.
Okay.
Now, I take it that there were, way back when, during the late 19th century, there were private paying clients or residents, and there were state subsidized residents.
This started out as an entirely private entity, them raising funds. You had to pay. The cities and towns had to pay. They used almshouses prior to this time, and so there was tuition. The reason that the Commonwealth got seats on the schools board in the first place is because it was a quid pro quo. We'll give you so much money every year, and you have to take these placements, 25 placements or whatever it was. And so initially, the corporation ceded 4 of 12 board seats to the Commonwealth in exchange for that block grant every year. I think 10 or 15 years later, they cede another 2 board seats to the Commonwealth in exchange for still further funds. But all the way along, they're raising private funds, they're having fundraisers, and that board makeup of the school never changed. At no time did the government, did the Commonwealth of Massachusetts or anybody else have any right to the governance of the corporation. It was always private. There's nothing in the record to support that statement.
And the appointments were all private. They were confirmed. Those that were confirmed were simply confirmed by the governor.
Ratified.
Ratified.
They were ratified. And that was legislation that was promulgated by the corporation itself so that it didn't lose the funding. Had they not done that, their funding was at risk. But all it did...
The Anti-8 Amendment.
The Anti-8 Amendment. But if you look at, it's a 1909 statute which is cited in our brief. The language that the governor had in 1909 when it took over a large share of the funding of the school, if not all of it. By that time, it's moved to Waltham. The difference between that 1909 statute and the 1918 language that tweaked it is very, very minimal. And as the trial court found, Judge Long found, if you look at the annual reports which are filed subsequent to 1918, there's no change. You still see the two separate entities. The state auditor audits the school's books, and the corporation has to go out and hire an accounting firm. They keep their assets at the Boston Safe Deposit and Trust Company. It's a separate private entity, and that is operated in the same way to this very day, much like a Chapter 180 corporation would be operated today by its members. They don't have shareholders. The members elect their board.
Now, after 1918, what does the corporation do? I mean, today, what does the corporation do? What is its corporate purpose?
To assist the past, present, and future residents of Fernald.
So it's still focused on assisting the Fernald residents.
And it is it has such a proud history, and it is a crying shame that it was forced into this to take back its own property, because it supports services where the government and families fall short. And that happens an awful lot when you have intellectual disabilities. The amount of them that are on their own is incredible, and the corporation funds those shortfalls. Thanksgiving dinners, Christmas presents, sensory libraries, things that the legislature won't provide and Medicaid doesn't provide, they kick in.
What are the if this is your property? I mean, assuming you win in this suit, what does the corporation plan to do with the property?
I would say that the plan remains the same, which would be to sell the property with the intent of hopefully, ironically, we were literally at a meeting with DCR to sell it to DCR when we found that this was encumbered. And so the
More
board,
legal fees than you would have purchased for the property.
right, and so the intent then and the intent now is to keep it open space, but to convert it into convert it into money and give it to the endowment and continue on with what they've done for 165 years.
Could I change to the other topic here, which is the executive heir type issue and the jurisdiction of the land court to hear this declaratory judgment action at all? Do you have any response to the suggestion that the case Cicero, whatever that 1960 case was, raises some doubt as to whether or not at the time of the executive heir decision that the Superior Court may, in fact, also have had jurisdiction?
It wasn't cited in the brief, so I haven't read it, but I have a lot of thoughts on that. I mean, that case is unfortunately a little bit opaquely worded, but
I mean,
Which case?
executive heir?
executive heir. But what it does say is that was land acquired by the Commonwealth. They bought it, and they owned it. And they tried to kick the person off who had a lease and ran an airport on the land. But they acquired it. They were the grantee name in the deed. We are the corporation is the grantee name in the deed, and the Commonwealth concedes that in its brief that corporation funds were used.
But that doesn't really speak to the question of whether, as your brother would say, you can drag the Commonwealth into court under the declaratory judgment action.
Well, these are great facts for Your Honors to decide this case, because this is a totally charitable corporation that does God's work, and they are the grantee name in this property, and they, without notice, without consideration, without due process, had it leaned up by the legislature. On what basis? They have, as we cited in our brief, in the 1990s, the Commonwealth commissioned a title report by Strzok, Strzok, and Levan that concluded that we own the property. Our own title examiner, both of these are part of the record, that we own the property. Is that the type of case? You own property, the government takes it, And now the argument would be that you have to go through the land registration.
You represent a very sympathetic client, but what's the principle here, and how would it apply more broadly and put the Commonwealth literally constantly to the task of defending such cases?
The Commonwealth, the legislature should not be able to take people's property without due process. And that's what they did here in this case. They took someone's property without notice, without due process, without basis. And even if you
So all land disputes, anytime a private entity disputes the Commonwealth's ownership of some land, they can just bring a declaratory judgment action? Is that the...
I would say that but for the carve-out of, I think executive heir is clear to the extent that if the Commonwealth owns the property, if they're the grantee in the deed, then you have to attack that in the land court, that certificate of registration in the land court. But for everybody else, that they just willy-nilly decide to lien up people's property or take it or transfer it.
But there may be other circumstances similar to this, in which at least quasi-public entities took title in their name rather than in the name of the Commonwealth. And how does that get resolved? How do those cases get resolved? And I take it there's a lot of land out there where that's happened.
I believe that's what the reason was for the Ward Commission, that the Ward Commission's conclusion by statute, I believe, was that if it's in the name of a state agency, that should be considered, or I don't know if they physically went to the Registry of Deeds or the Land Court and changed the grantee names, but that was the intent of the Ward Commission in 1980. But even after 1980, there was no change for the corporation. I just think that this is great facts for this, because this is an outrageous act on the part of the legislature to take somebody's property without any due process, and it's not close. They concede in their brief that the grantee, that it's corporation funds. They concede in the brief that the grantee name is the corporation, and they, with great respect, especially for trial counsel, they back into this and conflate over and over and over again. The briefs would be a lot shorter if there was no conflation of school, which was the place where the people lived and were cared for, and the corporation, which started the school and is a private entity to this day, especially according to the Secretary of State, the Attorney General's office, their own title examiner. Nixon Peabody did a title opinion. That's part of the record for the corporation. Gould, Title, and Worcester did a title search. Everybody's in agreement that we're the grantee except for the Commonwealth, and this great, proud organization has had to litigate this case to get its land back. So,
Thank you, counsel.
Thank you.